It's February 3rd, 2016. Welcome to the Institution for Higher Learning in Common Law. I'm your host, Joseph Farley. Let's get right into the teaching.
Go back to the document. In this document that we're putting together a manual of a step-by-step procedure on how you take these people to task in an administrative hearing. And the purpose of doing that is holding the public servants accountable for what they're supposed to do is vitally important. And we've covered this several times in our classes that the majority of people that get into a controversy with the state or federal government, their remedy, for the most part, when they go as a ignorant person of the law to hire an attorney over a traffic issue, let's say it's a traffic ticket that's $200, $275, or whatever the case is, they go into the courtroom, they get ripped apart, they're not heard, they're like cattle, they're sent out the back door, and now they're really mad and they want to get even, and they see the injustice and everything else. They go to an attorney, they're going to spend $5, $10, $15, $20,000 in order to get back into the same place where they're going to get some real injustice. The public servants realize this, and they understand that they have no threat whatsoever until someone understands, learns the laws, learns the procedures, and learns how to take these folks to task. We'll come back to this page in just a moment. In covering this, there are some terms in the statutes, and each code is going to have a definition section, and it's vital. You can't do anything without the definition because these words are going to mean different things under different codes. And so you always want to check that definition for a specific statute or code that you're dealing with. And again, these codes, as the name of this particular manual that we're putting together, Death by a Million Paper Cuts, is designed and outlined to go through a step-by-step to show you what they have to follow.
Not what we have to follow, but what they have to follow. Brad, go ahead.
I just want to point out that if you're going to go through these codes, not only do the codes themselves have definitions, but sometimes chapters and subchapters have their own definitions. So you can't just go to one place. You have to make sure that the chapter you're in doesn't have a definition of its own, because sometimes the definition will say, in this chapter, such and such a word means so-and-so.
Absolutely. And we've seen the difference in the past week of different chapters have different meanings, but we'll cover this. Section 311.016. May, shall, must, etc. The following constructions apply unless the context in which the word or phrase appears necessarily requires a different construction, or unless a different construction is expressly provided by statute. May creates discretionary authority, and I want to cover a little bit of this. We covered it last night, but I want to cover a little bit of this in order to give a backdrop of this. So discretionary authority is when a cop pulls you over in a traffic situation, he's going to have discretionary authority to do a couple things. And that is A, let you go, B, write you a ticket, or C, take you to a magistrate. Now, he does not have discretionary authority. As a matter of fact, he violates Texas law when he takes you to jail. And obviously, he doesn't have discretionary authority just to shoot you on the side of the road. So there's certain things that he has discretionary authority in, which means this opens him up, and they have not done this, I don't believe, haphazardly. They have put this officer in a precarious situation by allowing him to have discretionary authority. So if he violates a duty that he has,
then he has broken the law and can be taken to task.
But when he steps out under discretionary authority, it changes the whole event. So shall imposes a duty. Must creates or recognizes a condition of precedence. Is entitled to, these phrases or this word, is entitled to, creates or recognizes a right. May not imposes a prohibition and is synonymous with shall not. Number 6, is not entitled to, negates a right. 7, is not required to, negates a duty or condition precedent. Now, the reason that this is important is that these words are going to pop up in the lower text here. Subchapter C, construction of statutes. In order to understand a statute, you need to understand how it's built. Section 311.021, intention in enactment of a statute. In enacting a statute, it is presumed that. Now, presumption is what the courts completely operate on. And they are going to presume things until you hold them to task to show them that they can't do it. Now, the reason that they've gotten away with what they have gotten away with is that we have been ignorant of the law. We've been ignorant of the codes, the rules, the statutes that are not law sometimes in a statutory situation. And I'll show you that as we move forward. Number 1, compliance with the Constitution of this state and the United States is intended. Now, any law that has been enacted that's in violation of a state constitution or the United States Constitution is void in its enactment. So when they wrote that law, they passed it, they signed it, they sent it, and it turns out that that is a violation of state or federal constitution, then that's not a law. Number 2, the entire statute is intended to be effective. Number 3, a just and reasonable result is intended. 4, a result feasible of execution is intended. And 5, public interest is favored over any private interest. Now, number 5, I absolutely don't agree with, but that's here in their particular statute. And we can come back to that at a later point in time. Section 311.022, prospective operations of statutes. A statute is presumed to be prospective in its operations unless expressly made retrospective. The other day when I was putting this together and came across that word, I knew the definition of this particular word. However, I wanted to look this up. So once I did and saw this, I knew that they could not do this, but I wanted to find it and I wanted to show it to you. So Article 1, Bill of Rights, Section 16, Bill of Attainders, ex post facto or retroactive laws impairing obligations of contracts. No Bill of Attainder, ex post facto law, retroactive law, or any law impairing the obligations of contracts shall be made. So right here, they're already in violation in putting this together. And that's where you would go in order to exercise your right in defeating this particular area.
Section 311.023.
Statute construction aids. In construing a statute, whether or not the statute is considered ambiguous on its face. Now, let me stop right here. Ambiguous on its face. A lot of the statutes are very ambiguous, and they use that in order to give them latitude. Ambiguous on its face, a court may, remember that's one of the words that we just read, consider among other things, number one, objects sought to be obtained. Number two, circumstances under which the statute was enacted. Number three, legislative history. Now, in the legislative history, it's important for us to go back. We must always research what the legislative intent of a statute and how it is written. This applies to both state and federal. Agencies cannot write laws. So if you have a code or a statute or a regulation that does not correspond with the legislative intent, then that particular area is void as well. Number four, common law or former statutory provisions, including laws on the same or similar subjects. Number five, consequences of a particular construction, administrative construction of a statute. And number seven, title, captions, preambles, and emergency provisions. Watch right here in this next section. Subsection 311.024, headings. The heading of a title, subtitle, chapter, subchapter, or section does not limit or expand the meaning of a statute. So what they just did is they negated what they just said up here in section 7 above. Section 311.025, irreconcilable statutes and amendments. A, except as provided in section 311.031D, if statutes enacted at the same or different sessions of the legislature are irreconcilable, the statute, last, and date of an enactment prevails. So when you're going through these, if you find that there is a difference in these, the last enactment is going to prevail. If you don't know that, you may get okey-doked on a previous statute that's done away with to begin with. So it's always important for you to go back and check those things. B, except as provided by section 311.031D, if amendments to the same statute are enacted at the same session of the legislature, one amendment without reference to another, the amendment shall be harmonized, if possible, so that the effect may be given to each. If the amendments are irreconcilable, the last in the date of the enactment prevails. C, in determining whether an amendments are irreconcilable, text that is reenacted because of the requirement of Article 3, Section 36 of the Texas Constitution is not considered to be irreconcilable with additions or omissions in the same text made by another amendment, unless clearly indicated to the contrary. An amendment that reenacts text in compliance with that constitutional requirement does not indicate legislative intent that the reenactment text prevails or changes in the same text made by another amendment, regardless of the relative dates of the enactment. D, in this section, the date of the enactment is the date on which the last legislative vote is taken on the bill enacting the statute. E, if the journals of the legislature records fail to disclose which of the two or more bills in conflict is latest in the date of the enactment, the date of enactment of the respective bill is considered to be in order of priority. Number one, the date on which the last presiding officer signs the bill, the date on which the governor signs the bill, or three, the date on which the bill became law by operation of law. So there are several steps that they must take in this, and there's a lot of information through a PIR, that's a public information request here in the state of Texas, that you can send in order to get this information about the acts and the statutes. Section 311, we can skip that. Statutory reference. Unless expressly provided otherwise, a reference to any portion of a statute or a rule applies to all reenactments, revisions, or amendments of statutes or rules. Repeal or repealing a statute. The repeal of a repealing statute does not revive the statute's original repealed nor impair the effect of any saving provisions. So, in this saving provisions, what this is talking about is if they completely mess up on an enactment, anything that was done under that, they're going to keep it. So any inch that you give a state, even if you go back to have that overturned, they're going to go ahead and keep as many people inside that box as they possibly can, just as it says here, as if the statute had not been repealed or amended. So even though they have an illegal statute, they're still going to try to keep it. Okay, severability and non-severability. For sake of time, we'll move on here. Waiver of sovereign immunity. In order to preserve the legislature's interest in managing state fiscal matters through the appropriation process, a statute shall not be construed as a waiver of sovereign immunity unless the waiver is effected by clear and unambiguous language. In a statute, the use of persons, as defined by Section 311.005, to include government entities, does not indicate legislative intent to waive sovereign immunity unless the context of the statutes indicate no other reasonable construction. Statutory prerequisites to a suit, including the provision of notice, are jurisdictional requirements in all suits against a government entity. All right, now what we want to do is run back up to Section 311.005. So we're going to run back up here to 005 under their definitions. Person includes corporations, organizations, government, or governmental subdivisions of agencies, business trust, estates, trust, partnership, association, and any other legal entity. Now, it does not talk about individual like it does in some of the other codes. They could try to use an all capitalized letter name as a corporation. So when you have an issue in a court situation, you would need to file a form that states that you're not a corporation.
When I tell people about this, they don't believe me, so I've included this here along with the website where you can go check it out. It's Rule 52.
You're a people. And so that will correspond back down here with this particular 34. So now that you know what person means, let's read the sentence again. In a statute, the use of person is defined by Section 311.005 to include government entities, does not indicate legislative intent to waive sovereign immunity. Now, we realize that we are the sovereign, and as we see a little bit later on tonight, we give that to the state for them to manage. But that doesn't mean that we completely give it up and we've lost it. It's not that at all.
We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundations on such principles and organizing its powers in such forms as to them shall seem most likely to effect their safety and happiness. This government is on loan from us.
All right, Section 311.035, construction of a statute or a rule involving criminal offenses. Now, this is where this is going to get pretty interesting. Criminal offenses or penalties. A, in this section, actor and element of an offense have the meaning assigned by Section 1.07 Penal Code. Except as provided by subsection C, a statute or a rule that creates or defines a criminal offense or penalty shall be construed in favor of the actor. That very rarely ever happens in a courtroom. If any part of the statute or the rule is ambiguous on its face or as applied to the case, including, number one, an element of the offense, or number two, the penalty to be imposed. C, subsection B, does not apply to criminal offenses or penalties under the Penal Code or under the Texas Controlled Substance Act. So if there's a drug case, this is not going to apply. D, the ambiguity of a part of a statute or a rule to which this section applies is a matter of law to be resolved by the judge.
Can I bring up another point while you're there?
Sure.
This was a case of Adask versus Texas. Al Adask is a publisher of a number of newsletters and whatnot. He's a pretty sharp guy. And he got arrested for narcotics. And he won his case because of a provision in the Bible. And the provision was that we are to have dominion over or other animals or something like that. Anyway. So he said that the definitions in the code that described about who the narcotics laws applied to didn't apply to him because he was a man. And he ended up winning his case over it. So, yeah. Anyway, that's back to your text, Joseph.
Okay. Okay, so as we look at actor,
we're going to go back to this definition.
Actually, what I want to do is let me go ahead and pull this code up, even though I have it here because I need to get this set up for you guys anyway to show you something else. Chapter 1, definitions. Okay, Penal Code Title 1, General Provisions, Definitions. In this code, it's going to be number 2, actor. Means a person who, criminally responsible, is in issue in a criminal action. Whenever the term suspect is used in this code, it means an actor, element of the offense. Now, let me go back here in the actor piece. Now, this chapter referred back to the Penal Code. Actor means a person whose criminal responsibility is in issue in a criminal action. Now, this particular chapter defined what a person was. And it's a corporation. It said nothing about an individual. And we're going to look over in the Penal Code what that definition is. Remember, the whole intent behind this is for this to have harmony with the codes and the statute. And we can show very quickly that there is no harmony. Okay, definition. Element of an offense means a forbidden conduct, the required culpability, any required result, and the negation of any exception to the offense. All right, I want to bring your attention to something here. And as far as the liberty movement, I believe this will completely light you up here. Individual. Individual means a human being who is alive, including an unborn child at every stage of gestation, from fertilization until birth. Which means that in these abortion clinics, there's an ongoing case that I believe is here in Texas, and there was a group of people that went in and went to work for the Planned Parenthood and began to expose what Planned Parenthood is actually doing. Planned Parenthood's response to that, and has gotten all types of backlash, people appalled and everything else. Planned Parenthood's response to that is, hey, we need to indict those people for exposing our crime.
The filmmaker's actions does not negate Planned Parenthood's murder of innocent life. Who will hold these people accountable? Officers of the court? I don't think so. That's why you need to know how to do this.
This statute right here in Texas clearly says, now we talked about ambiguity. There's no ambiguity in this particular section of the penal code. What they've done is murder, and they've murdered these unborn children. So as a PAG, once you're ready,
there is no statute of limitations on murder. And I don't believe it would be hard to light up Planned Parenthood. I'm not saying it wouldn't be a problem, but I don't think it'd be hard.
All right. Let's go back to the text. Government Code, Judicial Branch. I think you'll find this very interesting. Subtitle A, Courts, General Provisions. Inherent powers and duties. Now, we read about duties earlier. This is an obligation of the courts. A court shall have all power necessary for the exercise of its jurisdiction. Let me stop right there. If it doesn't have jurisdiction, then the rest of this cannot be done. And the enforcement of its lawful orders. If it doesn't have jurisdiction, there are no lawful orders, including authority to issue writs and orders necessary or proper in aid of its jurisdiction. So, in a traffic, since we've dealt with traffic issues, if a court never had jurisdiction, according to Section 21.001, they can't even issue a subpoena, they can't issue a writ, they can't issue a warrant for arrest, they can't do anything under this, and this is their duty. Okay, B. A court shall, which is also a requirement, a duty, a court shall require that the proceedings be conducted with dignity and in an orderly and expeditious manner, and control the process so justice is done. Now, when you go into a court of record, what have you established? You've established jurisdiction. C. During a court proceeding, a judge may not request that a person remove an item of religious apparel unless. Now, when I read across this, I almost wanted to skip, but I've made a commitment to read every single word in the government codes, in the statutes, regardless how boring it is, or at first impression of how much I don't care about what they're getting ready to talk about. In making that commitment, there are diamonds that you find along the way, and I'll show you what those are. A party in a proceeding objects to wearing of the apparel, and 2, the judge concludes that the wearing of the apparel will interfere with A, the objecting party's right to a fair hearing. B, the proper administration of justice. Now, we've seen in the traffic courts, in courts of chancery, that there is nothing fair about the hearing. And there is no administration of justice the way that it's spelled here. There may be JUST-US for just them, but there is absolutely no justice. Now, a court has a duty. They have an obligation to provide you with a fair hearing. If they're not allowing you to enter information into the record, we'll cover this in just a second. Let me go to 3. No reasonable alternative exists under which the judge may assure a fair hearing, and B, protect the fair administration of justice. So, you would be able to use this in a court. Objection, judge. Your duty is to assure a fair hearing. I'm not getting a fair hearing here. You are not allowing me to enter the government code or law, whatever the code is, into the record. You are also to protect a fair administration of justice. So now, just with your objection, that's now been put in your particular record in that court. Now, when I'm talking about this is in a court of chancery, that if you're able to hold your jurisdiction in a court of record, you're not going to have to go there. But if you're in a court of chancery, this is going to be some of your provisions on appeal. Okay, before we move forward, let's review the Texas Constitution regarding courts and jurisdictions. Texas Constitution, Article 5, Judicial Department, Section 12. Section 12, judges to be conservators of the peace. Indictments and information. A, all judges of the court of this state, by virtue of their office, are conservators of the peace throughout the state. B, an indictment is a written instrument presented to a court by a grand jury charging a person with the commission of an offense. An information is a written instrument presented to a court by an attorney for the state charging a person with the commission of an offense. The practice and procedures relating to the use of an indictment and information, including their contents and amendments, sufficiencies, and requisites, are as provided by law. The presentment of an indictment or information to a court vests the court with jurisdiction of the cause. In Texas, and I believe that this is the same way throughout the states, that the court will point to the ticket itself and say, well, that gives us jurisdiction. And some of the, let me say this the nicest way I can, idiot judges will say that, well, the ticket is what gives us jurisdiction. Clearly, here in the Constitution, that is not what gives them the jurisdiction. They have to have a presentment, or they have to have an indictment, or they ain't got nothing as far as jurisdiction goes. Okay, Section 21 of this first chapter that we had started on in the Chapter 1 of the Government Code talks about contempt of court. This is important to remember. When you're holding a court of record, you would be able, well, you'll see it as we go through. Let me just go ahead and read it. A, except as provided by subsection G, a court may punish for contempt. B, the punishment for contempt of a court other than the justice court or municipal court is a fine of not more than $500 or confinement in the county jail for not more than 6 months, or both, such a fine and confinement in jail. C, the punishment for contempt of a justice court or municipal court is a fine of not more than $100 or confinement in the county or city jail for not more than 3 days, or both, such a fine and confinement in jail. D, an officer of the court who is held in contempt by a trial court shall, on proper motion, and you're starting to think, wait a minute, why isn't this guy going to jail? Well, he's an officer of the court. An officer of the court who is held in contempt by a trial court shall, on proper motion, file in the offended court, be released on his own personal recognizances, pending the determination of his guilt or innocence. The presiding judge of the administrative judicial region in which the alleged contempt occurs shall assign a judge who is subject to assignment by the presiding judge, other than the judge of the offended court, to determine the guilt or innocence of the officer of the court. Let's go back to officer of the court. Go ahead, Brad.
Well, you'll notice that if I'm in court and I'm not an officer of the court, and so far it hasn't told us what I have to do to put myself in contempt, but if I do that, I can get up to 3 days in a traffic court plus a $100 fine.
Yep.
Where's my due process?
There's no due process, and this is
okay,
unilateral.
But if I'm an officer of the court, now everything changes. As an officer of the court now, we have to have another special judge come in, and there's a hearing that has to be done, and testimony can be taken, and I think the 14th Amendment says something about equal protection under the law.
Exactly.
Okay.
Exactly. So, as the King's Bench, actually, what I want to do is open this real quick. Let me open this up. George, go ahead and open up for questions.
Okay. As I understand it, to avoid contempt, I've been told that you begin any statement that you have to make. You can say virtually anything that's not plain course. You can't talk about the judge's mother, that kind of thing. But if you begin the statement with something like, "With all due respect, Judge, this is what I understand," and then you say what you have to say. And at that point, you're basically telling him that he cannot hold you in contempt because you're respecting him.
Okay, I'd like to comment on that. That'll work the first time you try something, but let's use another example.
I've done it over and over again, like 20 times in one court.
I understand, but
when I got done doing it, the judge recused himself.
Okay. When you make an objection, for example, and the objection is overruled because it's immaterial or irrelevant or for some valid reason, and then the testimony starts again and you object again for the same reason, pretty soon the judge is going to say, "Listen, Tom, if you object like that again on the same grounds for the same reason, I'm going to hold you in contempt. He's warned you." And you can say respect all you want to. If you do that again, he's going to hold you in contempt because of the warning.
At that point, I think you can still say, "Judge, I have to protect my rights, and the only way I know to do it is to make a formal objection. It's your job to rule on the objection, but if I don't protect my rights, I lose them, and I know no other way to do it." Do you?
You make a good point, but I think what the judge is going to assume after a certain period of time, and only that judge can determine what that time is that you are using objections as a delaying tactic and in an effort to disrupt the court, not to actually file a legitimate objection, because he's already told you that objection didn't apply to that particular question.
Well, when you file an objection, again, as I understand it, I've not been in court as many times as you, but as I understand it, if you file an objection, it simply has to be filed before the next question.
That's correct.
So, I mean, you might want to file it before an answer, just so the jury doesn't hear the answer, or the judge doesn't hear the answer. But you really just need to file it once per question. And if they, every other word you're objecting with the same cause, then you are being obnoxious. But if and I've seen it. I mean, I've seen people object. Matter of fact, I saw it in the state Supreme Court when we were trying to get Obama off the ballot. The guy before objected several times, and the Supreme Court judge in this particular hearing finally said, "Look, you've made it clear that you object to that. I'll take it under advisement, and we need to move on. We're going to do this and be knowledgeable as long as we only object once per question. I think we're okay." And
yes.
Again, you've got to object. With all due respect, Judge, I have no intention of it's not my pleasure to dishonor this court. And what I might think to myself, you're doing a fine job of that all by yourself, but I'll keep that to myself.
Well, let's
and then state my objection as long as and again, if you're doing it every other word, you are being obnoxious.
Let me give you an example of what I'm talking about. In the Manson trial, where they convicted Manson of multiple cases of murder in the Sharon Tate deal, one of his attorneys was named Kunster, I think. And the question was asked, "Please state your name for the jury." And he jumped up and said, "Objection, Your Honor, it's hearsay." The judge said, what the heck are you talking about, a hearsay? And the way he explained it, it is hearsay. The only way that you know who you are is because your parents told you what your name is, and that's hearsay. The only way that you know that that birth certificate is yours is because your parents told you it. They told you that you were that person. You can send away to your state capital and get that birth certificate, but you can do that because your parents told you that your name was Tom. So it is hearsay. Well, of course, the judge said, yeah, forget that. We're not doing it. Well, he kept doing that, and the judge finally found him in contempt. He ruled on it and ruled on it and said, no, your objection's overruled. It's not hearsay. We know who we are. And he kept doing that, and then the judge found him in contempt. I don't know if that's a good example or not, but I think it is. Does that make sense?
I would agree with the judge in that case.
Yeah, I did too.
If I comprehend what you're saying.
Yeah.
Hey, Brad.
Yes.
Take this D, this subsection D, and let's look at this from a court of record. And would not the judge be an officer of the court?
Absolutely.
Would the prosecuting attorney be an officer of the court?
Yep. Would the defense attorney be an officer of the court? Yep.
All attorneys are.
Yep.
Mike, go ahead.
Okay, I didn't want to. I had our group muted because we were chatting a little bit, but while you were talking, to keep on point here. But if you go into a court, say they're charging you with a traffic, since we're doing traffic right now, but anything, and you open your court of record, you make a claim that somebody's bringing trespass on your property, such as fraudulent documents to the court, okay? They don't have any first-hand knowledge. You have your court of record. We get to this point where something is said and you object, and your objection's overruled. Well, you pause the court. You tell the court, I require pen and paper to properly answer this court. And with your court of record, you write on your piece of paper, the objection at such and such time over matter whatever is now overruled in this court of record. And only the jury can decide if your objection that you overruled was valid, just like they would have ruled whether the judge's ruling on an objection was. Only the jury.
Let me clear this up, because you're confusing me a little bit. The judge, you make the objection, the judge overrules your objection, and then you take the pen and paper and write this out, whatever you're going to write out, and now it goes to the jury. Is that what you're saying?
Well, actually, it's presented to both sides, and that being on paper makes it real. Everything else is words in the wind. The objection from the other side, objection from you is words in the wind. Actually, and you understand the words in the winds. Words in the winds blow away, but what's on paper is real and true and forever. So, like, even if you've got a court recorder in the courtroom, and the court recorder is typing everything down, only people under oath are real words that could ever be appealed or presented to a jury. Does that make sense?
Absolutely.
Okay. And when it comes to the common law in a court, very little is said out loud except for objection. And one of my favorite lines from one of Bill Thornton's cases was, I object. Your objection's overruled. Well, I still object. And your objection's overruled. And it's the third time, I object. And the judge says, well, you object to everything. And he said, thank you, Your Honor. I'd like that held in the record. Now you've objected to everything that the state is doing because there are no first-hand witnesses testifying through the most of the case. We come into these courts for a traffic ticket or whatever, and the state's attorney, he's not a first-hand witness. How is he allowed to speak in a court? I only want to deal with a claim with another man. I'm making my claim against Don, who's sitting over here to the left, that he didn't give me my $50 that he borrowed. He's already admitted he borrowed the $50, but he never agreed to the time he was going to pay me. Okay, we can let a jury settle that $50. but I'm not going to have a judge decide it. I'm not going to have a state prosecutor decide it or a defense attorney decide it. It's straightforward. Well, we have to deal with our public employees in the same way. They work for me. You have duties and obligations. I don't have any rights with my public employees. All my public employees have duties and obligations. As soon as I say I have rights, somebody's going to say, well, define those rights. Nope. Duties and obligations are everything that we're reading here in this statute and code. These are duties and obligations. And once you get to about 1,000 words or more, you can pretty much catch any duty and obligation being broken somewhere because it was enacted somewhere else. And a lot of this is all about this playing of a person and a people. I can be a person at any time in my life whenever I want, but I am always a man. I am always a people, always and forever. And if you understand that concept, you can manage your common law claim while dealing with their statutory administrative court in front of you, and you can run both courts at the same time. But it's really a lesson in a way of thinking. I mean, I was brainwashed for 50 years. I didn't catch this until I was 48, 49 years old, that, hey, I was brainwashed. I didn't know.
Well, oh, yeah, I Don, a man, in regards to that $50, shall pay Mike in the future.
Right. All these traffic codes where the word shall is sometime in the future. Is today ever the future? No.
It can never be the future. It's always today.
It's always sometime in the future. Well, it says you shall get a registration for your vehicle. Well, shall has not come up yet. It's a future tense. I will do it when it shall become due. It's a hard thing to teach because it's actually a way of looking at things and recognize that words are the trick that make all this statute, code, regulation, ordinance work. It's all play on words.
Word magic.
That's right. Well, here's the point behind this, and when someone reviews a statute like this, they're considering from the state side toward you, and that's not the case. These codes and statutes are for them. And an officer of the court, when you're in a court of record, you can't hold them in contempt of court, and then you can go to your administrative judicial regent or to your administration of this and say, wait a minute, it says that all people are created equal. We all have the same standards. We all have to abide by the rules. Would you agree with that? Well, of course, the administration is going to agree with that. Okay, well, this judge is in contempt. Now, he can be in contempt of Congress. He could also be in contempt of Supreme Court. He could also be in contempt of the court of record. And that's where we need to put our focus on, because we have all been brainwashed. We've been brainwashed through the media. We've been brainwashed and indoctrinated in schools. And this is a different way of looking at it. And America is not going to change as long as the criminals that are in our government are allowed to do whatever they want to, and nobody's going to stop them except the people.
You know, I've come across a lot of little words, and I've really done the study on the little words. As, of, for, you, your. These little words are very, very powerful. Like, I was in a district court one time, and I was very unhappy with a federal judge, or a district court judge, a state district court judge, excuse me, acted ridiculous in court. She didn't have a name. I figured, she should at least have a name. I came back the next day to the clerk's office, and I wanted to know who was presiding in courtroom, whatever, as a judge or a magistrate. This woman came up, and she presented a piece of paper with the judge's name signed on the bottom without any telltale sign, and she pointed to my name and said, "Is this you?" And I said, "Are you kidding? I'm me. That's just a name on a piece of paper." I said, "I want to know who is this person here? Could be a man or a woman who signed this." And then she went right back, and she asked me 15 times, is this you? And the clerk was trying to get me to admit I was a name on a piece of paper. And that's that part of you and your. You get pulled over by a police officer. I'd like to see your driver's license and registration. Do you make driver's license and registration? No, but once you say they are you or yours, you have admitted to the police officer, and that's why what judges never say to you and prosecutors never say to you that I asked him for his I asked, is this your driver's license and registration? And you said yes. You have been joined by saying it is yours. Now, I don't make driver's licenses. This belongs to somebody else because somebody can take it from me. If somebody can take it from me because I don't pay for it or whatever and I didn't create it, it's not mine. I only carry it for a convenience because people with guns can take me to jail for not having one. Or at least that's what they believe.
Good point. Okay, guys, we need to wrap this up. It's 9 o'clock, and we need to get into our other class.
Thank you guys so very much for letting us put our input in and everything that you put out here, and I appreciate all the work you guys do. God bless you.
You're doing a lot of work. We really appreciate it. Thank you.